Hey everyone, we're back for week 16. We're approaching the end here. We only have one more week after this. There will be an extra credit opportunity via survey pretty soon. I'm just sort of tinkering with it, but you just keep an eye out for it. I'll post an announcement on Blackboard with a push email to everyone. So this week we're going to continue where we left off. So this is the revised syllabus. You can see that we left off talking about the contract clause. We're going to continue with that with Stone, Home Bidding and Load Association, and then we're going to make a hard transition to looking at the due process clause. So we're going to look at the Slaughterhouse cases, which actually is more of an equal protection issue. And then Lochner, West Coast Hotel, and Williamson are going to be about due process. This, for those of you that are going to take Con Law 2, which will be offered in the fall, or if you're thinking about going to law school, or even if you're just going into law enforcement, this will be very pertinent for you, because this idea of due process is how we apply the Bill of Rights to the states. And so what we're going to see is initially the court's going to be very reluctant to understand what the equal protection and due process clauses mean via Slaughterhouse and Lochner. This period is actually referred to as the Lochner era. There's about a 30-year period where the court has this very bizarre view of what the due process and equal protection clauses mean, and they'll ultimately reverse themselves. And so this idea is also considered both by liberals and conservatives as one of the most disastrous eras in the court, because they're essentially making law from the bench rather than interpreting the Constitution. After that, we're going to make another hard turn. So we have sort of three topics: the contract clause, due process, and equal protection, and then which sort of go hand in hand because they're decided about the same time. And then we'll move into the Fifth Amendment, which is the takings clause, which is going to be Hawaii and the Kelo case. So with that, let's go ahead and jump into our first case here, which is Stone versus Mississippi. So just a reminder, these slides are all available on Blackboard. So let's begin with Stone versus Mississippi. Again, a very old case, 1879. Here, this looks at whether or not the state of Mississippi should allow the sale of lottery tickets. You might be thinking, this is stupid, like who cares about lottery tickets? But at the time, this was considered something very controversial. In fact, there's a quote from this case that I think uses the word, or words, I should say, the words of something like a tax on like the feeble-minded or something. So this idea of like gambling is considered this really, terrible moral opprobrium. We have to stop all people from doing it. Nowadays, of course, it would seem really silly, but at the time, it was considered a great vice. So the legislature of Mississippi allows for the sale of these lottery tickets, as it says here, for 25 years, right? However, they then decided to change their mind. And when they ratify the Constitution of 1869, a revised Constitution, it, as it says here, forbids the state from ever authorizing a lottery with an enforcement mechanism. This should be enforcement. There we go. With an enforcement mechanism via statute, right? So you can see how this could create a problem, because you've essentially allowed the businesses to conduct industry, right? These gambling or these lottery organizations, and then you've pulled it back via state constitutional amendment. So the question here, as it says, did Mississippi violate the contract clause of the Constitution? The court's going to say no. So again, we're looking still at Article 1, Section 10, contract clause violations. Let's look at Justice White's majority opinion and see how he arrives at that. So he starts with Trustees of Dartmouth College versus Woodward, which we looked at last lecture, the 1819 case, and they said that has become embedded precedent. But what this means is this: not that the charter itself is not essentially protected. Rather, only contracts contained in charters matter. So if there is no contract, then there's nothing in the grant which the Constitution can act on. And so what they say here, what they're essentially saying is that charters granted to businesses aren't protected by the contract clause. Rather, only contracts in charters are what matter. If there's no contract in the charter, then there's no constitutional protection. So we have to ask this: was there a contract here, or was there simply a charter, meaning a grant by the state? The answer, they say here, moving into Section 2, is essentially no. That the state can't bargain away its police power. In other words, the fools of the past should not be obligated to abide by the future, right? So like, just because you had a bunch of idiots in the legislature in the past doesn't mean your hands should be tied if you're a state. So not only did it not enter into a contract, but it can't enter into one where it gives away the state's sovereign ability. And they say, quote, irrevocable grants of property and franchises may be made if they do not impair the supreme authority to make laws for the right government of the state, but no legislature can curtail the power of its successors to make laws they deem proper in the matter of policing. So the idea there is, again, you can't, just because you have one foolish legislature in the past doesn't mean you can tie the hands of the legislature in the future. This actually raises an interesting question, and for those of you going to law enforcement or law school, whatever, it's an interesting question about, what about things like private prisons? So would that not be acceptable under this theory? Because you're essentially tying the hands of the legislature to say, look, we've given this contract to a private business, they're going to enforce the incarceration of these people. Does that mean that you could never violate, you can never cancel that contract, right? This gets into the question of, like, can you tie the hands of the legislature or not? And it's sort of open-ended. One of the other issues here, too, it's not on the slide, but they mention it, and I said this at the beginning of the Stone case, was the court talks about the evils of lotteries and how they, quote, infest whole communities, and it, quote, reaches every class. It preys upon the hard earnings of the poor, and it plunders the ignorant and simple. And this is the idea that lotteries are like a tax on the stupid, which is a very odd sort of way to, interpret that. But anyway, so moving on to point 3. So as it says here, could a legislature, via a charter, to a lottery company, defeat the will of the people? In other words, are the hands perpetually tied? The court here says no. And if you look back to the trustees of Dartmouth College versus Woodward case, their Chief Justice John Marshall added a caveat to his decision, and he said that the founders did not mean to give the U.S. Constitution this power to, quote, restrain states in regulation of their civil institutions adopted for internal government. He says, so therefore the consequence must be that the majority here sees this exercise within the limitation and scope of the power of the states. And then finally, the fourth point here, they say that the contract clause was meant to apply to property rights, not governmental rights. Lotteries may be accepted, but those companies must understand that such a grant is at the will of the people via their legislators. So think about how in the Charles River Bridge case, how they granted this company the right to build the bridge. Doesn't mean that they granted them sole monopoly rights, and that is that the contract must work. Contracts from government must work in favor of the risk taker. In favor of the government against the risk taker. So you've sort of gambled by entering this. It doesn't mean that one day your industry, or be it bridge, be it transportation method, whatever, will not one day become antiquated. So, for example, what if we invent flying cars? We granted you the right to build a bridge. We don't need bridges anymore, right? So that you took that risk, and that burden is on you, not on the government, to protect your monopoly. And so they say lotteries can be accepted, but those companies have to understand that the grant is the will of the people, via the legislatures, and only they can choose to re-enable the charter, not like a perpetual grant of permanent maintenance of the industry. Okay. Next, let's turn to Home Building and Loan Association versus Blaisdell. This case is from 1934. So this case, as it says here in the opening bit, is that there's a Minnesota law. They had this Mortgage Moratorium Act, 1933. So this is like Great Depression period. And they wanted, as it says here, to extend the period of redemption for the foreclosure of sales for a time deemed equitable by the state courts. The idea here is that they're trying to, there's a bunch of foreclosures on these homes, and they want to create a sort of buffer period. So they said that the mortgagor was required, the mortgagor, the person granting the mortgage, was required in order to get the extension to pay some sort of fixed value, and this was fixed by the courts, to the taxes and the interest and the insurance and the mortgage, but was given an extended period to do this. So the idea here is that it doesn't really make sense to foreclose on homes because banks don't want a bunch of homes that really have no value, and people want to keep their homes, obviously. So if you're looking for sort of a recent, sort of related instance, think about the housing bust recently, before sort of the end of the W. Bush administration, when Obama just took office, right? There's this big housing bust. They're giving all these, suboptimal loans to people that really couldn't afford them. The idea here is sort of trying to remedy the same situation. That is, banks don't want homes, people want to keep their homes. Let's come up with some sort of solution. So the question here then is, well, does that Minnesota law violate the contract clause because you're essentially granting this extension, right? Oh, one other thing here too, if you're curious what this Blaisdell et ux, that's et ux means et uxer, it means and his wife. It's a husband and wife. So the court ultimately says this is not a violation of the contract clause. And so take a look at the language they use here. The sanctity or inalterability of contracts is not set in stone. There could be interests in the state that supersede those particular private interests so long as, and this is not on here, but so long as they are still satisfying the conditions of the contract. So in regards to the equal protection claim, they actually take up quite a few issues. One is, as it says here, the main one we're concerned with, which is the contract clause. They also look at an equal protection claim, 14th Amendment. In regards to that equal protection claim, the court says, quote, we do not think that the statute denies to the appellant the equal protection of the laws. The classification which the statute makes cannot be said to be an arbitrary one. And so they're saying, look, this is not like some sort of like discriminatory enforcement. And on the concerns that we're most focused on, they say in terms of due process and equal protection and as well as contract clause, they say that, for, quote, for the same reasons that sustain it, under the contract clause, the legislation as applied in this case is consistent with the due process clause of the 14th Amendment, and then they also say it's also consistent with the equal protection clause. And the idea there is, and the sort of the big takeaway from this case is that contracts under the contract clause cannot be violated. That does not mean that they could not be sort of accommodated, I guess is the way to approach it, right? So, like, well, we'll see this when we get to the next slide, but the state essentially has a lot of authority to attempt to accommodate both the risk taker by the venturer, the contract issuer, and the risk bearer, which is the person withholding the contract, holding the contract. So they first look at whether or not this is a constitutional violation, right? And they say that emergencies obviously cannot create power. The Constitution is set in stone, right? There's no new rights that can be breathed into this. So this doesn't increase granted power or remove power or diminish power under the Constitution, under its sort of enumerated clauses. But they say the Constitution itself was made in a period of emergency, right? We were sort of just reconciling the war effort, and so they say that emergency might not create power, but it could furnish the occasion for the exercise of power. In other words, like, let me give you an example. The war power isn't created by an emergency, by war, but given Congress's authority to declare war, they could meet that emergency. That doesn't remove constitutional limitations on protections for individual liberties. This understanding of the Constitution is a bit controversial, and typically we see it, for those of you going to law school, this will be very important. Typically we see a liberal-conservative divide, and so classical conservatives on the court would be willing to say that the Constitution speaks with a different accent during times of war or even great emergency. Liberals on the court would say that's irrelevant. The Constitution can only have one possible meaning, and that is what it means, right? What it says. And so what you'll see is that there's sort of a debate. Increasingly, though, we've seen liberals and conservatives fall slightly more in line in terms of the Constitution not taking on new meanings. So think back. Oh, good sort of test question material. Think back to. Let's see if you can recall this. This is actually a question from the last exam. Now that I think about it, it's not going to roll over, so it won't be a test question. But maybe see how good your memory is. Think back to Korematsu, right, where we said internment of Japanese Americans is okay, and the argument of the court was, look, during times of war, perhaps the Constitution has a different, implication. This does not invoke equal protection analysis. And then look at Trump versus Hawaii, where the court says, even with a conservative majority, because this is still the current composition of the court, no, right? The Equal Protection Clause means one thing. You cannot discriminate on the basis of race. You can't simply assume racial guilt, right? You can't, because you're Japanese American does not mean you're automatically loyal to the Japanese. The Equal Protection Clause must guarantee these protections of race-based discrimination. And so what they're saying here is sort of an antiquated notion, and that is, maybe the Constitution has a different voice. The court today, however, very reluctant to say that same thing. So going back to the case, what are we left with? They say that the contract clause, when debated at the Constitutional Convention, those debates are essentially of little aid. So where do we look? They look at precedent, right? So how we decided in the past. And they cite a few cases here: Stone versus Mississippi, which we looked at already, Beer Company versus Massachusetts, and Fertilizing Company versus Hyde Park. So what they say first in the Stone case, we already looked at, was the lottery's decision, right? State constitutions which put an end to a lottery, which are authorized by the legislature, they said was fine. The lottery was a valid enterprise when established under express state authority, but the legislature, acting in the public interest, could put a stop to it in the Stone versus Mississippi case. And they say similarly with alcohol, there's a similar rule that applied to the control of by the state of the sale of intoxicating liquors, which is what this Beer Company versus Massachusetts case dealt with. And then finally, they say that the states retain adequate power to protect public health against the maintenance of nuisances, despite insistence upon existing contracts. And so think about this fertilizing company cases. Think about if you have like a polluter, right, that's causing harm to the public. Does that mean that because there's an existing contract, the state is powerless to act to prevent this nuisance? And they say no, right? If you had, imagine, for example, this weird situation, but sort of like a Captain Planet villain who's just polluting for the sake of polluting, does that mean the state is powerless to stop it because they've entered into a contract with that party? No, right? They have this policing power. And finally, they talk about the regulation of public highways in a case called Sporles versus Binford, which is not listed on here, but in that case, it dealt with the regulation in the use of public highways by common carriers and what they called contract carriers, where the assertion of interference with existing contract rights essentially didn't gain traction there either, right? So what they ultimately conclude then, and this moves into point 2b here, is talking about, well, the petitioners are trying to say that, look, if you look at all these, it says here, if you look at the cases that are cited above, this plus the Sporles versus Binford case, that those are really only incidentally infringing upon the contract. So this isn't like an instance I mentioned above with the fertilizing company case versus Hyde Park, where you have, somebody that's doing something that's otherwise illegal, or the infringement by the state is only incidental. It's small, right? It's only incidentally affecting these contracts. And so they try to say that these cases above are really just incidental restrictions. They're not pervasive infringement of the contracts. But the court, as it says here, is going to say no, right? They say it misses the point. And what they say is that the question is not if the actions affects the contracts incidentally or directly or even indirectly, but the question is if the legislation is addressed at a legitimate state end, and if the measures are taken are reasonable and appropriate by the state to work towards some legitimate governmental goal. And so another argument, they sort of continue with this, and the petitioners here are trying to make this various arguments, trying to make one of them stick, which is often the case. And they try to make another argument that says that the state power may only be addressed to prevent some sort of enforcement if the contracts raise the issue of actions that are hostile to public morals or health or safety or welfare. In other words, only if it infringes upon one of the guaranteed state police powers, health, safety, morals, and welfare. The court says no, right? They say when states, while states cannot use the power to destroy the limits of contracts, meaning they can't just simply veto a contract, that would be directly against and antithetical to the contract clause. For example, they couldn't do a policy that would allow the state to simply cancel contracts or ignore debts. It does not mean that there will never be an instance where a, quote, temporary constraint of enforcement may be consistent with the spirit and purpose of the constitutional provision, meaning the contract clause. And thus, it could be within the power of the state to protect the interests of the community, even though it might work against those individual contract interests. Finally, last couple points here, 3 and 4. The third point they raise here is the state, they say, retains the power to meet these, quote, extraordinary conditions that may be deemed to be a part of all contracts. Specifically, they're talking about the aforementioned interests of public welfare, and if state power exists to give temporary relief to the enforcement of contracts because of some sort of disaster. So think about like a fire or an earthquake. Then why wouldn't that also include relief from disasters brought on by economic hardships, not just things like acts of God, right? So the court recommends a compromise between the individual needs via the contract and the public welfare. One of the problems, though, with this argument is that if we're looking at national versus some national like acts of God, like earthquakes, fire, stuff like that, versus an economic disaster, essentially, aren't they always? I mean, they're it's really hard to distinguish sometimes because oftentimes they go hand in hand. So you could have an instance where an earthquake leads to an economic disaster, or, for example, COVID-19 creates both and it's an act of God because it's an occurring virus, right? It wasn't manufactured, and it's also an economic disaster. So essentially, you could essentially argue that the same thing. So doesn't this give like a really broad power to the state to recognize these things, and then say, well, contracts can bend essentially to accommodate these natural disasters and economic disasters. But anyway, and then finally, the last point here is that it talks about these criteria for specifying the conclusion that it ultimately reaches, and you can read these on your own. Was this an emergency? Yes, a legitimate emergency in Minnesota. That the legislation was aimed at that emergency. The relief was appropriate. The legislation seeks to aid all those involved and avoid the ruin of both the parties. So it's not just the investor or the contractor and contractee, but rather both parties. And then finally, it was temporary, right, to handle this emergency. So they ultimately conclude, yeah, it's just fine. Okay, let's move to Sutherland's dissent. So he starts off by... Oh, there we are. So he starts off by looking at what is the purpose of the contract clause. He says it's to prevent states from impairing private contracts. Right? This should be a very intuitive understanding of what the purpose of the contract clause is. So he says that if we assume that the purpose of the contract clause is to prevent the impairment of the private contracts, the majority claim of emergency is essentially the ability to impair these private contracts, but they also claim that emergencies are not an allowance of the increase of power. And so take a look at the quote here. He says that this brings exercise. Yet the majority also says emergencies don't create power. They say emergencies don't diminish a restoration upon power. It furnishes an occasion for diminishing it. But this is essentially the same thing, right? You're just rewording your claim, right? You're essentially creating a circular argument. He goes on to say that there's nothing, no emergency could soften the restriction prohibiting the states from altering contracts, and that the Minnesota law either impairs contracts or it doesn't. If it does not, then there's no concern here, since it's within the state's power. If it does infringe on the contracts, no emergency can justify furnishing the exercise of state power in this arena. To suggest otherwise, he says, is, as the majority does, is to argue, again, a circular sort of line of reasoning. Right, doesn't make sense. And then finally, the fourth point: if allowed after contracts were created because of some sort of emergency justification, then where is this ending? Right, you've essentially created a perpetual loop of excuses, and there's no limit to the end of modification of contracts because of national emergencies, which you could create on the fly. So the question of whether the legislation is wise or unwise is, as he says, quote, a question entirely irrelevant to the issue. The only legitimate inquiry we can discuss is whether or not this is constitutional. And he says this is not. So let me give you a little aftermath of this case before we move on to U.S. Trust Company of New York. In the 4 decades that followed this Blaisdell decision, most cases rejected contract clause attacks on state laws, but this did not mean that there was a sort of validity of all state measures. In the next case, we're going to sort of see an example of this, of how this is not like a blanket restriction of simply saying, okay, I have an emergency, therefore I can do anything I want to private contracts. And so the final case, one of the final cases we're going to look at is this reining in of, this is the final case in the contract clause line that looks at how far can you take this? Is it sort of like a blanket grant to the states to say, okay, as long as we have an emergency, we can do whatever we want, or is there some point of reining in? And they're going to say there is, right? It's not like carte blanche. You can't simply do whatever you want. So let's turn to that case now. So as it says here, in New York and New Jersey, they established an interstate compact, which states can do, and there's actually quite a few of these, typically between neighboring states when they have shared resources, like, for example, interstate mass transit systems, or sometimes like shared waterways or aquifers, things like that. But 12 years later, they both repealed this, and a company that was a bondholder said, you're violating the contract clause, right? So the court here is going to answer that question that sort of leaves open one that remained from the Blaisdell case we just looked at, and that is, could there be if we simply say emergency, does that mean I can say I can designate anything an emergency, and therefore I have free reign to repeal these contracts? And here they're going to say this did violate the contract clause, right? You cannot have retroactive repeals. In the Blaisdell case, the court says that there was an exception, right? There were emergencies that states could declare that would warrant the modification of contracts, right? But they say not all alterations of contracts, as it says here, are essential attributes of sovereign power. So what does that mean, right? That's kind of vague. So they clarify on the next slide. Justice Blackmun goes on to say that while the states have really broad powers to adopt regulatory measures without worrying about the effects on contracts, that private contracts are not subject to unlimited modification by simply claiming some sort of police power, as it says here. So the question is, well, when then, right? So they say the issue is this. When the states start to impair their own contracts, it's not enough to simply say we're going to defer to the legislative assessment of the reasonableness. Because if a state could reduce its financial obligations whenever it wanted, the contract clause is essentially meaningless, right? It doesn't really provide any protections. So unlike Blaisdell, here we have the state trying to modify a contract for its own personal benefit, right? That seems to be the distinction. Fourth, they say that the Appellees, New Jersey, claim that the goals of this repeal are so important that the public benefits outweigh any sort of private claim, right? The court says no. A state can't simply refuse to meet its legitimate financial obligations simply because it would have preferred to spend the money on some other public good. It would only be permitted if it was reasonable and it was necessary to serve an important state purpose. So here the state's trying to claim it wanted to reduce traffic and reduce congestion by encouraging these mass transit systems by raising the tolls. And the court says this is not a necessary goal, nor is it a reasonable one given the facts. And so they go on to sort of detail why this is not sort of necessary action. And they say here, because it doesn't, a total repeal wasn't necessary, they could have used some less drastic option than simply repealing the entire contract, and then states could have achieved this without modifying the contract at all. This is a little bit odd because it sort of implies that the burden is shifting to the state. And the problem with the conclusion is, is it necessary based on your assessment of the evidence? It doesn't really seem like an objective measure, but nonetheless, that's what the court arrived at. There is a dissent by Brennan. Brennan, his main point can be held in this first bullet here, or first numbered point, and that is that, look, in the past we said lawful exercise of state police power are more important or greater than private contract rights. So in the past, state police power, that trumped private contracts. That's how I read Blaisdell. But here, it doesn't seem to be that way. It seems to reject that understanding. The framers, as he reads it, of the contract clause meant to protect private contracts, but that did not mean state obligations, right? It just meant private contracts between two private parties, not ones entered into with the state. So what do we take away from this? Well, we take away that laws impairing a state's own obligations are entitled to less deference than legislation interfering with private contracts. Therefore, there's sort of a heightened standard of review for impairing state obligations that must meet some sort of reasonable, necessary purpose, and it must serve some public purpose, right? So there's sort of an increased burden. Finally, the last thing I have for you is, this is purely in my slides, and they're also available on Blackboard, and that is, have we seen any updates? There haven't really, like I said, been a lot of contract clause cases because the retroactive insolvency clauses that states have added have sort of made them kind of meaningless, but there was this case from 1978, just a year after the U.S. Trust Company case. This Allied Structural Steel versus Spanish case. As it says here, 5-3 decision. It invalidates the Minnesota Minnesota Private Pension Benefits Protection Act. God, that's a mouthful. And it says here it required the employers to make these pension payments, or retirement plan payments, also hard to say. And and so what they wanted to do is say, well, can we stop? Can we stop paying into this plan? In other words, what happened is the employers had to pay, you had to pay a fine to the state if you wanted to cancel the pension plan. Or you could choose to, as it says here, close a Minnesota office. This was meant to be a way to ensure that the employers didn't back out on pensions, on these retirement plans, and leave the employees high and dry, right? Here the business, this Allied Structural Steel, closed its Minnesota office, and it was charged about $185,000 because some employees had worked there for more than 10 years, and under the law, they said, they had to pay the penalty because they didn't want to leave these people without some sort of retirement plan. So, as it says here, what did the majority rule? They said that this Minnesota Act's imposition of a new obligation on the employer was a violation of the contract laws. That this was more than a mere temporary modification, right? This was permanent and immediate, irrevocable, and retroactive. And so this gets into that same idea that we saw in this New York Trust Company case, right? You're making these radical changes, and when the state's doing it, trying to sort of get out of its own obligations, that the burden is heightened. Right? Okay, that is it for our contract clause cases. Let's move on to the 14th Amendment. So we're going to look at, real briefly, the Slaughterhouse cases. The Slaughterhouse cases actually address a bunch of provisions of both the 13th and 14th Amendment, and the reason why is because they were new, right? If you look at the time, the 13th and 14th Amendment were relatively new creations, right? So what we see here is that there's going to be an attempt to say, okay, well, what does the 13th and 14th Amendment mean? Because it has a bunch of provisions, and we don't know what any of them mean. They're going to try and throw everything they can at the wall and hope something sticks. Nothing sticks. One of the big takeaways out of this case is we're going to see the court's going to express a very vocal reluctance to expand any of these provisions. 13th Amendments, ban on slavery, or any of the provisions of the 14th Amendment, including privileges or immunities clause, due process clause, or equal protection clause. The most important thing probably to take away from this, if you're looking to just sort of summarize this case in maybe like one word or a couple words, would be death of privileges or immunities. Because of this decision, the court will say that the privileges or immunities clause of the 14th Amendment essentially has almost no meaning. And that will still be true today. That clause essentially is meaningless. It has almost no value, and the court will be very reluctant to expand it. The only exceptions to this, for those of you that are maybe like Second Amendment gun rights advocates or something like that, you might be interested that there have been some members of the court, particularly Justice Thomas, and I think Gorsuch, maybe Gorsuch, but Thomas was really the only vocal one to argue that we should breathe new life into it, and it should be for gun rights. That's a privilege or immunity, this idea of self-defense. No one else, he did this in the one of the gun rights cases, either the D.C. versus Heller or the McDonald versus Chicago case, I can't remember which one, but nobody else co-signed with that. He's, as always, pretty radical. If you take Con Law 2, you'll actually see both of those cases, the Second Amendment gun rights cases. But for now, let's focus on this. So the Slaughterhouse cases, sometimes you see this as one word as opposed to the hyphen. It doesn't really matter. The full name of this case is actually, why it's called the Slaughterhouse cases, is a consolidation of several cases. The full name of the case is the Butchers Benevolent Association versus the Crescent City Livestock Landing and Slaughterhouse Company, which is a mouthful, so most people simply call it the Slaughterhouse cases. So this case raises an issue, and that is, if you've ever been to New Orleans, which is a fantastic city, everybody should go, really great. It kind of smells like an open sewer in a lot of places, and that's today. Imagine if it's 1870 or 1869, and they were dumping animal carcasses in the river. Probably not a good thing, right? So what's happening was people were dumping all these animal carcasses from slaughterhouses into the water supply, and it's causing things like malaria, and it made everything smell really bad. So Louisiana passed a law. Oh, there should be a comma right there. Louisiana passes a law that says only these two slaughterhouses in New Orleans have the ability to dispose of animal carcasses. They've essentially granted a monopoly to these two slaughterhouses. So you remove the livelihood of everybody else, right? So a bunch of these other butchers and slaughterhouses file suit against the state, claiming that, look, we don't really know why, but we've got these new amendments, 13 and 14. They got a bunch of clauses in there. We don't really know what any of them mean. So let's try and claim all of them and see if any of these things stick. And the court's going to say no, 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 no. And the privileges or immunities clause is essentially meaningless. So there's and this is still really the precedent today. There's really been only one other case, which I believe your book features, a 1999 case, Sands versus Roe, that actually does talk about the privileges or immunities clause, and I'll mention that when we get to the end of this, but it seems like more like an anomaly. Back when this case was decided back in 1999, people thought, oh, maybe the Slaughterhouse is being revised, maybe we're tossing it out, but it doesn't. It seems to be that, no, Slaughterhouse is really still the binding precedent for privileges and immunities clause, or privileges or immunities, excuse me. That is the one other sort of confusing thing about this case, besides its enormous name, is that there are two clauses in the Constitution that sound almost identical. And that is, in the 14th Amendment, there is a privileges or immunities clause. In Article 4, Section 2, there's a privileges and immunities clause, which the court has interpreted to guarantee a citizen of one state the ability to enjoy equality in all other states. Basically, the states can't discriminate against you based upon where you're from, right? But this also has sort of very little in the way of legal meaning. The book actually, I think in several places gets it wrong and refers to privileges and immunities when they mean privileges or immunities. I've actually emailed the authors, and they said, oh, yeah, you're right, we screwed up, we'll fix it. And they never fixed it. But either way, since they both don't really mean anything, it's not really that important, I guess. Okay, so let's go through this case, and then I'll talk about some of the later adaptations and adjustments the court has made. So the out-of-work slaughterhouses and butchers say, look, we got a bunch of arguments here. Let's start first with the 13th Amendment. Can we claim that this is giving us, this is essentially making us slaves, involuntary servitude? The court says no. We interpret the 13th Amendment to say that it is literal slavery. Does not mean it can prevent monopolies. That's all it was meant to do, was to prevent former blacks from being enslaved. That's it, right? The court, as we'll talk about in one of the upcoming cases, in the, I think we have it on here. Let me double check. Yeah, they'll kind of mention it in West Coast Hotel. I guess we're not really doing it. There's one other case that, well, yeah, if you take Con Law 2, there's a case called the Civil Rights Cases where they will say that the 13th Amendment doesn't mean just slavery. It can mean sort of the badge of inferiority. But in this era, in 1873, the court's saying literal slavery. That's all the 13th Amendment was meant to prevent. Okay, cool. So let's move on to the 14th Amendment. We've got a bunch of provisions, right? Due process, equal protection, privileges or immunities. We're going to focus mostly just on the privileges or immunities claims, but the court will reject all of them. So the court says, what is the purpose of the 14th Amendment? The purpose of the 14th Amendment was to correct a wrong that the court committed, and that is Dred Scott. This is referring to Dred Scott versus Sanford. We did much earlier in the semester. And remember, this was the case that said that there's no such thing as national citizenship, that only states can determine citizenship. The fact that Dred Scott went to a free state did not mean that he was entitled to be permanently free. It's sort of a perverse, weird understanding of the Constitution. And then ultimately the court says, well, look, that's what the 14th Amendment was done. It was meant to rectify this harm, right? What's going to happen, though, after this, so if you note the date, is that the court's still going to allow separate but equal accommodation in Plessy versus Ferguson. And that's not going to be overturned until Brown versus Board of Education, right? So the court says, well, what is the purpose of the 14th Amendment? It was meant to establish national citizenship. It was meant to overturn Dred Scott. None of those things are relevant here. This is not a matter of citizenship. This is not a matter of slavery, right? So that's not that whole purpose claim, just sort of a broad 14th Amendment thing, doesn't work. What about then this provision about privileges or immunities under the 14th Amendment? So the language of this clause actually says, quote, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. So then they ask two rhetorical questions. Basically, what the hell does this mean? The first one is, was the purpose of the 14th Amendment to transfer all state legislative power to the federal government, including those over civil rights? Which is a stupid question anyway, because you know the answer is going to be no. And then the second one was, how can Congress enforce this provision if it was intended to bring within Congress's power the entire domain of civil rights belonging to the states? And again, the answer is they can't, right? So they're asking these sort of stupid questions, which the answer is obviously going to be working against the Privileges or Immunities Clause. And so here's what they conclude. Take a look at this quote. Given this, quote, we may hold ourselves excused from defining the Privileges or Immunities Clause. In other words, we don't really know what it means, and we're not going to tell you what it means until some case involving those privileges may make it necessary to do so. So basically, you swung and you missed. Come back when you got a real one, right? But the court can, quote, venture to suggest. I hate when they do this. They don't really do it anymore, but in some of these older cases, they would say, look, we don't know what this means, but we'll tell you what it means anyway. Just say it, right? So they say, well, venture to suggest what they mean. The Privileges or Immunities Clause includes these rights. Now listen to this list, and it is the most bizarre listing of things that they have, right? Things that we should be guaranteed under Privileges or Immunities. You have the right to come to the seat of government and petition the government. So you have the right to travel to, like, Austin and yell at lawmakers. You have the right of the government. You have the right of government protection, meaning the government has to provide something like national defense and policing. You have the right to engage, and this goes on to the next slide, to engage with the administration of government. Oh, great, I can fill out paperwork. That's one of my privileges or immunities of citizenship. You have the right to access seaports and courts. Why are those two things in the same clause? Seaports and courts are very different. Unless we're having on a cruise ship and they got a judge on there, I don't know why they put those in the same clause. Protection on the high seas or in foreign territory. So this is referring to things like right to be protected by pirates, I guess, and right to access to, like, an embassy. The right to peaceably assemble, that was kind of redundant. You already had the petition argument in the very first clause, so why do you put that there? Okay. The right to obtain the writ of habeas corpus also doesn't make sense because that is already in the Constitution, that the right of habeas corpus shall not be... Remember, habeas corpus is... It means literally to keep the body, and that is, you can't throw somebody in jail. They have to be told why they're being detained, right? So you have to be brought before a magistrate to be arraigned. That right is already in the Constitution, so why would the Privileges or Immunities Clause also include that? Because that would just be completely redundant. And then finally, you have access to navigable waters. Again, what's their obsession with seaports and waters and high seas? I have no earthly idea. But that weird smattering of rights, that is what they say the Privileges or Immunities Clause means. Basically, it means nothing, right? It's a sort of bizarre listing of rights that don't really seem to have anything in common with one another. You'll notice here, too, that there's an absence of... On the opening slide, it mentioned the Due Process and Equal Protection Clause. The absence of this is because of the date. The court was really reluctant to say, look, we don't really know what any of this means, but it clearly doesn't mean due process or equal protection, right? So they basically just skipped over those arguments entirely. Yeah, so let's go on to Field's dissent, and then I'll give you sort of an update on what's... Field and Bradley's dissent, then I'll give you an update on sort of what's happened after. So Field dissents. He says, look, let's look at the language of the 13th Amendment. This clearly was not meant to simply apply to slavery because it also talks about involuntary servitude. So when he looks at the 13th and 14th Amendment, he says that, look, this is meant to be broader than simply this really narrow reading. And also, we don't really, if you look at the time that they were passed, it seems like the 14th Amendment was meant to supplement the 13th Amendment. They were meant to work hand in hand. So from there he said, look, even if you don't like that argument, they still should have won because of the Privileges or Immunities Clause. What does it mean? And he says here, I think it means government protects life, liberty, and property, which is actually a John Locke, the philosopher, sort of quote. Or not sort of, it is a quote. And so he says, therefore, quote, among these must be placed the right to pursue a lawful employment in a lawful manner. The problem is that where is he getting that language from? Life, liberty, and property are, as I mentioned, a John Locke philosophy thing. That does not exist in the Constitution, right? I mean, there's similar language in the preamble to the Constitution, but nothing actually in the language of the Constitution. And then finally he says that states, the third point, states must be fairly using police powers. Okay, let's turn to Bradley's dissent. There we go. So just these 2 points. First, he says the remains of 14th due process and equal protection claim that the court basically averted. Avoided the entire argument itself. And he says that I think that the 13th Amendment should have broader meaning. He says, as it says here, on the 13th Amendment, it is futile to say that only blacks are meant to benefit. Clearly, this was not just at African Americans that exist in the country. It should have benefited all people, right? So let's talk about some of the aftermath and updates that are not listed on this slide, but I'm just going to sort of give you some information about. If you're not thinking about law school, you can just skip over the next few seconds of the video. So what are we left with when it comes to the Privileges or Immunities Clause? Not a lot. While we can debate if Miller's opinion is correct or if the Privileges or Immunities Clause of the 14th Amendment was meant to be interpreted this way, it's essentially moot. And the reason why is because since this time, the court has rarely relied on the Privileges or Immunities Clause, and the instances that it has done them have been pretty flimsy. There's only been about 3 to 4. Most of them were the sort of turn of the century 1900s to there's like a 1908, 1935, and a 1940 case. There was one case that's somewhat recent. 1999, I mentioned it earlier. Sanz versus Roe. Sanz spelled S-A-E-N-Z-V-R-O-E, Roe. And people thought that this was going to breathe in new life to the Privileges or Immunities Clause. Just to give you a little background on that case. Here, the states, this was a case out of California, I believe, and states would receive what the California wanted to prevent people from coming to California to claim a public benefit like welfare. So they would only give people the amount of money that they would receive from their home state. Right, so like if you came from Oregon, and let's say they would give you like $500 a month, but if you were a California citizen, they would give you $1,000 a month. We're only going to give you what your home state would have given you, right? So the court there held that this was a violation of the Privileges or Immunities Clause. And the reason why was they said that you have a fundamental right to travel. That was one of the things that we should take away from the Slaughterhouse cases. And this right to travel is threefold. You can enter and leave a state without impediment,
You can be treated as a welcome visitor, and for those that become citizens, the right to be treated like all other residents. So here, the court uses the Privileges or Immunities Clause to strike down this duration residency requirement for this California welfare system, and they said it's an impermissible infringement on the right to travel, and that holding Congress's approval of this requirement didn't make it constitutional. But since we haven't had, meaning that Congress didn't basically object to it, but given that we haven't really had another case like this, it seems like it's more of an anomaly. As I mentioned, there have been a couple other instances where we've seen members of the court propose this. We've also seen instances where in other cases, people have tried to breathe new life into this. For example, I think I remember reading about an amicus brief in the same-sex marriage case of Birchfeld versus Hodges. Somebody tried to make that marriage was a privileges or immunity provision, right, of national citizenship. The court didn't even address that at all. And as I mentioned, Justice Thomas's concurrence in the Washington, D.C. versus Heller case dealing with Second Amendment rights tried to argue that this is why the Second Amendment applies to the states, why they can't, and the District of Columbia, they can't restrict access to the right to bear arms because this is the right, defense, basically. It's a privilege or immunity, but again, nobody signed on to that idea. Okay, let's move on to Lochner. Let me move this out of the way. As I mentioned at the beginning of this video, this Lochner case is going to be super, super odd. And the reason why is the court's going to breathe into the Constitution a right that doesn't exist in the Constitution at all. They basically just pulled it out of their collective butts. And this is considered one of the worst decisions. Not the worst by far, but definitely one of the worst decisions because they're basically making law. It's considered sort of judicial activism at its worst, right? So a little background on the sort of the cases that leading up to Lochner. Early cases before Justice Marshall became the Chief Justice and sort of reined the court in often relied on natural law justifications. These are called seriatim decisions. Now, you might be thinking, well, what is natural law? Natural law is sort of an argument that sort of a philosophical belief that certain things should be should belong to people, right? The problem, of course, with these seriatim decisions is that they don't have any basis in law, right? There is no statute, there is no constitutional provision, they're basically just making it up. So when Justice Marshall got on the court, he persuaded his colleagues to stop relying on these arguments because we have a constitution. We don't need to just sort of pull things out of our butt. We can just look at language. So with the growth of industrialization, there was this increasing demand for legislative response to these laissez-faire economic theories because people were getting really left behind. There's huge economic disparities. So with this, we also saw the rise of the idea of what's called substantive due process, and that is not simply so. There's procedural due process under the law, right? You have access to the courts, you have, a right of habeas corpus, you have the right to an attorney, those sort of things. There's also substantive due process. So here, when we're thinking about due process under the law, we're talking about Fifth Amendment due process. For substantive due process, we're thinking about 14th Amendment. So here is, we're thinking, just sort of give you the general idea. This is how the provisions of the Bill of Rights are going to be applied to the states. Right. So the 14th Amendment, the court will interpret to say that the 14th Amendment is meant to apply the provisions of the Bill of Rights, not just to the federal government as they're originally worded, right, but also to the states on a case-by-case basis. This process is called incorporation, right, applying these provisions of the Bill of Rights to the states. So the court here, however, is going to take a very odd view of the due process clause, and they're going to say it means essentially almost nothing, and what it does mean is not found anywhere in the Constitution. And this period is going to last, which actually we'll get to the next case. It's going to last until West Coast Hotel versus Parrish in 1937. So it's basically a 30-year period referred to as the Lochner era, because this is the period of time by which members of the court subscribed to this very bizarre interpretation of the due process clause. And it's considered sort of one of the worst eras in judicial history. And the court, even today, will still make reference to the Lochner era about it being long dead and incorrectly decided. So as it says here, take a look. Found guilty of violating a New York law. Take a look at what it did. Limited the number of hours bakers and confectioners could work per day. It's still pretty long, work requirement. You might be thinking, how hard is it to be a baker? But in 1905, a lot of these bakeries existed underground, and they were poorly ventilated, and they were extraordinarily hot. So nobody likes dead baker in your bread. It's just gross. So they were trying to basically stop the mass death of a lot of these bakers by creating very reasonable workplace condition stuff, right? So we don't want you working so long because you'll die. You're more likely to pass out or, be fatigued. And we see these, think about today how silly this would be. Because look at what they say here, right? that law regulating work hours, it's a violation of the Constitution. Today we see these all around, don't we? We have like OSHA, the Occupational Safety and Health Administration. We have, minimum wage, all sorts of stuff. And we say, yeah, perfectly fine, right? There's nothing in the Constitution that doesn't prevent the government from doing that. Here, though, they're going to say it does. That you have a right to individual free contract. You're basically like sort of like a work prostitute. Well, I guess prostitutes are a worker. Well, anyway, you can basically like whore yourself out to any unscrupulous employer. And that's fine, right? It's your choice. Hey, you want to work for this guy? You're probably going to come home with 9 fingers instead of 10. That's your choice. It's your individual right to contract. The problem is that does not exist in the Constitution. There's a contract clause, right, which says that the state will not violate private contracts. But this idea of individual contracts to basically work for anybody you want for as long as you want in the most deplorable conditions, that is your right? Nobody would want that, right? That's not a right. That's the punishment. Nobody wants to have that. And that's what makes this case so bizarre. Where are you getting that from? This right to individual free contract is not found in the Constitution. There is no clause that corresponds to that. You're making it up. And that's why this is considered one of the worst decisions. Okay, let's go to Peckham and see his reasoning. So take a look at the first quote here from Peckham. The general right to make a contract in relation to his business, meaning the employee, his business is part of the liberty of the individual protected by the 14th Amendment of the Federal Constitution. Where in the 14th Amendment does it mention the word individual right to contract? That word contract is not found in the 14th Amendment. You're pulling out of your judicial butt, right? But he says there are state police powers. So does this law exceed them? And he's going to say no, right? That there is no reasonable ground for interfering with individual free contract. Bakers can work, there are other hazardous jobs. Bakers can be one of them. If they want to work in a hellhole, good for them, right? The problem is the court is saying this, that it may be true, and this is actually a quote, I think, from the case. It may be true, it is, quote, it may be true that the trade of a baker does not appear to be as healthy as some other trades and is so vastly more healthy than others. This is a stupid logic, right? This shouldn't be a weighing game and seeing one is better or more safe. The question should be if there's a legitimate state interest that's guaranteed under the constitutional power. But it isn't, right? They're just making it up, this regulatory power. So they say bakers are really no different than other hazardous jobs, and that the real purpose of the law is to regulate work, but this is a violation of this, as it says here, a right of an individual to, contract themselves between their employers and the employees. Again, not found in the Constitution, totally making it up. And Harlan, in his dissent, is going to point that out, right? He's going to say this is just complete garbage. Harlan says that, look, you got a quote here. It says, like, the right to, liberty to contract can be regulated because why? The states have police powers. The 10th Amendment specifically says that everything not mentioned in the Constitution is left to the states. We've interpreted this to mean health, safety, morals, and welfare, right? And here we say the court, and here the court has consistently said it will not question the actions of the state or the federal government unless it is plainly and palpably in excess of legislative power. This doesn't seem to be one of those issues. Police powers include these regulations. The court should simply stop there, no further. Secondly, you cannot assume that the state acted in bad faith or there's some sort of greater constitutional power. We should always remember one of the in Chapter 3, there was one of the sort of fundamental assumptions of law in that under U.S. common law, things like standing and mootness and ripeness. One of them was the presumption of constitutionality, and that is that the burden is on the person challenging the law to prove that it's unconstitutional, not on the state or the federal government to justify their actions. It doesn't work that way. Here, you're reversing the way that we interpret this, right? Finally, Holmes, I'm sorry, I forgot he also has a dissent here. The majority is, as he says here, perverting the word liberty found in the Constitution, that state laws can regulate life in many ways. And he gives examples like Sunday closure laws, usury laws, which are high interest rate bans on high interest rates. And there's some of these go back to ancient times, and there's modern examples too. Things like prohibitions against lotteries. We've never questioned these, but now you're raising those into doubt. So let's move on to the rejection of this era. The court teases. Well, I'll go ahead and transition to the next slide and give you a little background. It's not on here, but I'll just tell you about it. The court teases that Lochner needs to die, and they do so in a case called Nebbia versus New York in 1934. Nebbia is N-E-B-B-I-A versus New York. There, in a 5-4 decision, the court upheld a law that regulated the price of milk. And so in the next case, we're going to see the solidification of this rejection of the ability that states can't, create sort of health, safety, morals, and welfare stuff. Yeah, and so we actually, as I mentioned, you'll still see these references to Lochner being so poorly decided today. For example, I mentioned earlier the Obergefell versus Hodges case in 2015, which held that there's a fundamental right to marriage, same-sex marriage, if one was so inclined. And the dissent there would say that the state, in enacting bans, they don't even have to be wise bans; they just have to be rational bans, right? The court, though, however, in the majority in that 5-4 decision, is going to say no. There has to be more than simply, there has to be. The court there is going to hold that there is a constitutional guarantee to marriage, and therefore it's not simply the deference to the states in terms of rationality. This West Coast Hotel case is going to be the court realizing that this Lochner era is stupid, and this line of cases needs to end, and this is going to be the one that really overturns it. A little bit of background to this case, and if you're hopefully you're listening closely, potential test question, and here's how here's what's going to be. This case, it goes by another name, and that is the switch in time that saved 9. The switch in time that saved 9 is called this because it saved the court at 9 justices. And the switch is referring to Justice Robert, who previously had been upholding that. Well, let me give you a little background, then it'll make more sense. So FDR is in office, right? Roosevelt's in office. He's passing all this New Deal legislation. It's the Great Depression, right? So the court keeps striking down all this stuff in 5-4 decisions. Franklin Delano Roosevelt floats the idea of adding something like 7 justices to the Supreme Court so that he would definitely have a majority. Because remember, Democrats controlled the presidency with Roosevelt, and they controlled both chambers of Congress. So he could easily get these through the Senate, right? When the public hears about this, there is a huge backlash. They think it's just you're manipulating the law. It's a terrible idea. He ultimately doesn't do it. But what happens after this is Justice Robert flips. He starts going from striking down New Deal legislation to now upholding New Deal legislation. Some people accused him of bending to the threat by FDR. However, in his autobiography, he claims that it wasn't this, that it was actually, just his change of mind. So in this case, we're going to see that switch in time that saves the court at 9 because of this Justice Robert flip, and it's going to be a 5-4 decision. If we skip ahead just a few years to, I think, about 1940 or so. Let's see if I have it in my notes. I think it's about 1940 or so. The court, the remaining justices on the court have died. So those 4 dissenters have died or retired, and FDR had replaced them all with justices more in line with his ideology. And by about 1940, they were 9-0 upholding New Deal legislation. So if I ask you what the switch in time that saved 9 refers to, it's the change by one of the justices to uphold FDR's legislation to keep the court at 9 justices. Or for short, you could simply say a change that kept the court at 9 judges as opposed to more. Right? Okay. So a lot of people assume that this case was going to. I mentioned before the Nebbia case, and there was a little bit of inconsistency because that was in 1934, Nebbia versus New York. In a 5-4, they upheld a law that created a board to establish minimum and maximum retail prices for milk. Nonetheless, that case seemed like it might have actually been an anomaly so they sort of hinted that maybe they're going to change their mind. But 2 years later, in a case called Moorhead versus New York ex rel Tipaldo, meaning ex rel, remember, is ex relatione, meaning New York is representing on behalf of this party, right, in the relation of. In that case was 1936, just 2 years after the Nebbia case. The court struck down a New York minimum wage law for women. I don't know why it was just for women, but there you go. So a few months after that, FDR announced his court packing plan, and then, lo and behold, 1 year later, or in the next term, we get this case, the switch in time that saved 9. So West Coast Hotel, this reversal, notice how radically different it is from Lochner. Look at the law. Washington State, 1913 law, commissioned to ensure minimum wage and working conditions for women and children. I don't know why just those, but whatever. And so she, Parrish, claims that she owed back pay because the company was in violation, West Coast Hotel, was in violation of the state law. The question here is they try and attack both the individual right to contract, Fifth Amendment guarantees, and due process guarantees, and also a reevaluation of the due process clause under the 14th Amendment. The court says it's fine, right? Here, Rather than viewing this regulation as a taking of property and a windfall for employees, the court views the failure to regulate as, quote, a subsidy for unconscionable employers. So from this point of view, the regulation isn't redistributive. It concludes that the distribution of the product of the government and the government inaction is as much a form of distribution as government action. Right? It's a total revision of what we saw in Lochner. So let's look at how they get there. So Hughes says, the conventional historical account suggests that Justice Roberts, he debates on whether or not he actually was, pressured to do this, but either way, he ends up being the sort of deciding vote here. Justice Hughes starts us off by saying, look, West Coast Hotel relies upon some precedent in Atkins. In this Atkin case, the West Coast Hotel Company, the unscrupulous employer, says, look, hit the precedent on our side. This was a 1918 congressional action that applied a minimum wage for women and children employed in D.C., in Washington, D.C. And the court there asked basically the exact same question. Is this either a 5th or 14th Amendment violation? And the court there said that they struck it down. They said upholding the statute would, quote, dangerously extend the police power of the state and therefore was unconstitutional. So West Coast Hotel is on pretty strong footing. Look, we have precedent on our side, right? Justice Sutherland, in that case, said that he, quote, recognized the freedom of individuals to make contracts is not absolute, and curtailments of this right may be justified in the face of exceptional circumstances. However, in this case, the statute's implementation procedures were overly vague and did not regulate the character or method of wage payments or the conditions and hours of labor in areas in which regulation to protect the public welfare were legitimate. In other words, Congress had simply enacted what he called a price-fixing law. So, given that they have this on their side, how can they prevail, right? What Hughes goes on to say, and this is in point number 2, is that, look, Parrish is saying, look, this is why it's a violation. This is my individual, you're basically hurting my ability to work. Where in the Constitution is there this idea of an individual right to contract? And they say, well, your rights as an individual, not necessarily just contract, but your rights as a worker are protected via the Due Process Clause of the 14th Amendment. And so they say that the question then becomes, if that's the case, who is going to protect those rights? Who's going to protect you from these unconscionable employers who just want to manipulate you and work you to death? The state, right? The state has the police powers to regulate health, safety, morals, and welfare. And so as they say here, blah, 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 protecting women and children is an exercise of that power. So that's the idea. Right. So, of course, not surprisingly, Sutherland is going to dissent because he was the one that authored the Atkins case, which this one is also overturning. Sutherland's going to say this is a blunt exercise of police power, that the law doesn't specify what payment is needed for health, safety, morals, and welfare, and that this is, as he says here, a naked and arbitrary exercise of police power. But here the court is going to, ultimately say, that's it. We're abandoning this idea of inventing a right to individual contract. Clearly, we should defer to the state to regulate things like working conditions and hours. Right. So that means the end of the Lochner era. That also means then that the court is no longer going to interpret the Due Process Clause in its same restrictive way. It can have totally new meanings, and because of this, they will eventually, about 10 or so years after that case, start applying provisions of the Bill of Rights to the states. This is the idea, as I mentioned, of incorporation. Similarly, just 1 year later, the court will also say, not only do we need to reevaluate how we've been interpreting the Due Process Clause of the 14th Amendment, we need to reinterpret how we've been looking at the Equal Protection Clause of the 14th Amendment. And they do so, in this case, U.S. versus Caroline Products Company, in a footnote, oddly enough. This is sort of outside of... I don't think it'll be a bonus question. It definitely won't be a short answer question. It's a little outside the scope of this course, but for those of you that are going to take Con Law 2, this will be a big sort of focus. So it might be worth your time. Or if you're thinking about either taking Con Law 2 or going to law school, you probably should just listen to this bit. If you're really not interested, it might not be that relevant for you. Maybe for sort of law enforcement purposes, because sort of why do we have these rights under the Bill of Rights apply to the states, not just the federal government? It might be interesting. Otherwise, if you want to skip it, I won't be offended. So just what happened in this case was it was a federal regulation that was trying to regulate. Apparently, people were like adding crap to milk, like powdered milk. So they're adding like chalk and all sorts of other gross stuff. I don't know. I guess to save money. So the federal government created a law and it said, look, if you're going to sell milk on the interstate commercial marketplace, you can't cut it with disgusting stuff. So they hear this case and they have this It has not. You may be thinking that has nothing to do with equal protection. That has nothing to do with like discrimination on the basis of like race or religion or anything like that. So how could you possibly get that out of milk, right? The way they do it is sort of this weird footnote. It's considered the most famous footnote in all of constitutional law. It's footnote 4. And what they say is that they have this sentence saying, look, when you're talking about regulation of economics, it's as long as the government has some sort of rational basis, and that's the words they use, some sort of rational basis for the distinction, it's fine, right? And then at the end of that sentence, they have a footnote. So, and then this is what the footnote reads, and this is a quote, copy and pasted from the footnote. It says, however, right, there could be a narrower scope for the operation of the presumption of constitutionality, meaning, remember that that's one of the assumptions of common law, right? We will presume something is legal, presume it's constitutional, state or federal, and the burden is on the other person challenging the law, right? But there could be an instance where it shifts, and it's not on the person challenging the law, but rather it shifts to the government to justify the law. So when would the burden shift to the government? There may be an instance for a narrower scope of that presumption of constitutionality, burden shifts to government, when the legislation on its face is within a specific prohibition of the Constitution. For example, one of the first 10 amendments, which can be embraced within the 14th Amendment. So you can see what they're doing here, right? So we're saying that we may need to think about the provisions of the Bill of Rights, the first 10 amendments, applying to the states, not just the federal government. Because remember, that's how the language is worded. It says Congress shall make no law in the First Amendment. It doesn't say states can't make a law. So there may be an instance where the burden will shift to the state or the federal government to justify the law when it raises one of these first 10 amendment issues. And then they have this weird sentence. We don't need to inquire whether similar considerations and blah, blah, blah. But when you have review of statutes that are directed at these particular religious, national, or racial minorities, national meaning national origin, right, where you're from. He says when you have these prejudices against discrete and insular minorities, right? So think discrete referring to, this is discrete R-E-T-E, not like E-E-T. Discrete spelled D-I-S-C-R-E-E-T is like don't be discreet, don't show your genitals in public. This is discrete as in like categories or bins, right? Insular meaning self-contained. So you're thinking about how, if I said like, what is your religious affiliation? You could tell me your religious affiliation. There's no spectrum. In counterpoint to this, think about like age. Age is not a discrete and insular minority. I can't say like you are old, because what is old, right? Age is a continuous spectrum. Think also about economics. What is rich, what is poor, right? There's a spectrum. There's not a discrete or insular class, right? And they say when that happens, there may be a special condition which tends to seriously to curtail the operation of these political processes, ordinarily to be relied upon to protect minorities. So, in other words, when you start targeting people because of their race or national origin or their religion, then there should be a correspondingly more searching judicial inquiry, meaning we will now put the burden on the state to justify their law, not the person challenging the law. So we mentioned this when we took up the Korematsu case. Remember, that was the one about interning Japanese Americans. In that instance, we say there's going to be stricter scrutiny, and that's what they call it, strict scrutiny, right? So what they've developed is a two-tiered system. Rational basis when it deals with something like economics versus something like when it targets people because of their race, national origin, or religion, strict scrutiny. And that means the burden will then shift to government to justify the law, right? Okay, let's look at a more modern interpretation then of the Due Process Clause. This Williamson versus Lee Optical Company is simply an example of how the court now approaches the Due Process Clause now that we've ended the Lochner era. It's really not much else to it, just to give you more than just an example, right? So as it says here, this is a 1953 Oklahoma law, and it stated that the fitting, duplication, and replacement of corrective glasses, may only be performed by a licensed ophthalmologist or an optometrist with their express and written permission. This is a bizarre law, right? You can clearly tell that these ophthalmologists and optometrists lobbied the legislature, probably with maybe campaign contributions, so that they could have this virtual monopoly over making glasses. I mean, what's the worst that's going to happen? I mean, you pick somebody's nose? Why do you need an ophthalmologist or an optometrist to do this? It just doesn't really make sense. So the question here is this a violation of the Due Process Clause by requiring these people to make these, despite the fact that it's just kind of a stupid law? And they say it's not. That it's just the duty of the court to say if a law is a violation of the Constitution, we'll strike it down. If it's an unwise law, that's not our problem. So in other words, yeah, this may be stupid, but that's not the concern, right? So let's go to the reasoning by Douglas. He says the reasoning of the district court held that the Oklahoma requirement, as it says here, was a violation of the Due Process Clause because it wasn't, quote, reasonably and rationally related to some sort of health, safety, morals, or welfare concern. But we've seen something kind of like this before in Lochner, right? The court says no. We're no longer going to evaluate legislation on if there is sort of, reasonableness or if it's simply just wasteful. They say that there's a presumption of necessity. This is the idea of presumption of constitutionality, and there's going to be a deference to the state legislatures. And the only other time is when if you're making an equal protection claim, right? But here we're simply talking about due process claims. And so what they say here is that the Constitution doesn't require a law to be logically consistent with the aim or the goal, which is kind of weird to say. Basically, like, we're not going to fault legislators for being idiots. That's not what the Constitution prevents. It doesn't prevent stupidity, right? The day, as they say here, is gone when we used to allow those sort of arguments, right? The wisdom of legislation, and that's the death of the Lochner era, right? So they say, well, what do you do then, right? This is a stupid law, right? Where do you take your complaints? You take it to the polls, right? We have a democratic system. You simply vote the people out of office. Yeah. So the aftermath of this is that there has never been, after Lochner era is over, right, and the West Coast Hotel era is reined in, no socioeconomic law has ever been overruled by the court since 1937 on substantive due process grounds. Never. It's never happened, right? So this could raise a question that if conceivable rational relationships are enough to establish some sort of legitimate governmental end, is there no instance where the court might have gone too far, right? Seemingly no, right? Yeah, I guess that's about it. The only other exception to this, maybe you could argue, and I think actually in the sort of leather-bound con law book that's in the library, if you maybe wanted to check it out if we're back on campus, is they talked about there was a case BMW versus BMW of North America versus Gore, and similarly State Farm Mutual and Auto Insurance you relied upon the due process clause for whether or not there at some point punitive damages could be in excess of the due process clause, and the court did say yes. In the State Farm case, they said that double-digit punitive damages. Punitive damages, remember, there's two types of damage: compensatory damages, where you compensate somebody for the harm monetarily, and then punitive damages, where you punish somebody for doing something. Typically, it's civil cases, right? And what you're trying to do is like deter other bad employers and companies and stuff from doing something similar. So you're like not only making up for the harm through the compensation, but you're punishing them to deter other future bad actors. They said that double-digit punitive damages were in excess of the due process clause. So there has been some application of this to in the modern era, despite the fact that Lochner is long dead, but that's really the only one. Okay, that's it. We're done with those line of cases. Let's move on to the last topic we'll be looking at in this course, which is the Fifth Amendment's takings clause. So, as it says here, the Fifth Amendment contains language. Let me actually pull up the clause itself. There we go. So the Fifth Amendment says, blah, 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 grand juries, blah, 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 blah. And then when you get to the very last sentence, which I don't know, most of this is just all about militias and service danger, due process. And then at the very end of this clause, which is all about, procedural due process, for some reason the founders tacked on this eminent domain provision, which says that, so you can't be forced to bear witness against yourself, deprived of life, liberty, property without due process of law. And then look at the very last clause, nor shall private property be taken for public use without just compensation. So this is, as it says here, also referred to as eminent domain, the taking of private property for public use. Now, you might be thinking, well, why would you ever need to do that? It's actually, you can think of a lot of instances, right? So, for example, what if you want to build a highway, right? And the only way is to move somebody's house, right? So if the person refuses to move, does that mean the government should be able to seize their property and then build that road there? Yeah, they can, but it has to be for public use and for just compensation. We won't be spending a lot of time debating the just compensation bit. And the reason why is because the court really settled this in a case called Monongalia versus United States in 1893. And they said that just compensation means, quote, a full and perfect evaluation for the property taken. I'm sorry, full and perfect equivalent for the property taken. So there really is very little debate about whether or not the government's giving somebody enough money. Usually they offer them more than enough, right? And oftentimes eminent domain is really the result of like several refusals of the party to be willing to give up their property. So like the government will say, look, we'll give you this money, we'll help you, all sorts of things, try and accommodate you, but we need this property. And then after various refusals will the state resort to eminent domain and simply take it. These are also referred to, as it says here, takings clause cases, right? Because you're taking the property. So what we're going to focus primarily on is the taking of the land, taking of the property, not just land, and what you're doing with it, and then that idea of public use. Because remember, it says taking property for public use. What constitutes public use? So we'll start with the Hawaii Housing Authority versus Midkiff case. As it mentions here, Hawaii, before it became roped into being a state, was a monarchy. It was ruled by a king, and the government, when it was replaced with one that was democratically elected, there's an attempt to diversify land holdings. And the reason why is because there were a very small number of families, basically descendants of royalty, which owned the vast majority of land in Hawaii. So, as it says here, in the 1960s, there were efforts made to break up this concentrated landholding, and this was done by condemning particular lots, redistributing them to a number of owners, which is the Hawaii Housing Authority would be in charge of the redistribution, and then they would compensate these people. So basically, we're just trying to say, look, you've got like a bunch of rich people that own all land in Hawaii. In fact, it was like something like over. It was massive. Oh, there it is. It's 47%. So 49% was federal or state owned. 49% was. 47% of the land in Hawaii was owned by just 72 property holders. So it's overwhelmingly concentrated in a small group of families. So the question here is, did this taking for public use via redistribution, is that a violation of the takings clause? The court's going to say it is not a violation, that it is okay to do this. This is considered a public use, right? So what they say, this case stems from a somewhat similarly related case called Berman versus Parker back in 1954. And there the court upheld a Washington, D.C. eminent domain power, use of power to sell or lease condemned private lands to other private buyers under the premise that it was for the greater public use. And that's really the crux of this issue. Is the state's use of its police powers, it's compensating these people, but is that a legitimate means to serve a public need by redistributing land out of the hands of just a handful of families? Or, well, 79 is not a handful, but you get the idea, right? So a small consolidation, 72, not 79, a small consolidation of these families. They say it is fine, right? And so take a look at what O'Connor says. Eminent domain is a means to an end. It's simply a means for the government to exercise power for public good, assuming it's used legally. So, is it used legally? Yeah. The court says we leave it up to once the states sort of take this action, the role of the court is simple and narrow: ensure the legality of the state action. So, was this action legal? Right. So they say what we will determine the Fifth Amendment to mean is that there has to be a public purpose, right? Public use is part of that requirement. And so they cite a case to give sort of an example of why this is okay. It's called Old Dominion Company versus United States. It's from 1925. There, the United States used land for war purposes. They were like testing planes, like bombing runs, stuff like that. And Old Dominion Company refused to renew a pre-existing government lease of their property. So the United States said, okay, fine, we're going to claim public use, we're going to compensate you for the land for military purposes, we'll give you, just compensation. Of course, they had the power to do that. The question was this: well, wait a minute, you've built some buildings on this land, which we used to lease to you, so do you have to compensate us for the buildings that you yourself built, the government, right? Or do you simply have to compensate us for the property? There they said the government, since the government erected these buildings, they were not, they said, required to compensate for those. And the reason why was this is clearly a public use. It's military use. Now, one of the arguments there, though, is, oh, wait a minute, if it's a military like base or facility, it's not, is it really public? Because if those of you that are in the military or maybe a family in the military, as you know, you can't just walk onto a military base, right? You have to be either a dependent or a retiree or somebody actively serving. It's not like any other civilian could simply go onto a military base, right? So is that really public use? The court says yes, because it's still benefiting the public, because the military is a service to the public, and that is defense, right? So they say that you can't, and this is key, you can't transfer ownership, but the idea of public use can be pretty broad, right? So here Hawaii says we're trying to regulate this oligopoly of ownership. This is basically trying to break up this, elite group of families owning all the property. They say that's fine, that's good enough, right? So this is actually a pretty broad sort of interpretation of the Fifth Amendment, and I imagine for many of you, you're probably like, damn, that's like really excessive. Maybe some of you sort of object to this. When we get to the Kelo case, it's really going to be the next one and the final one. It's really going to be sort of the pinnacle of takings clause analysis, and what we're going to see because of this Kelo decision is a big backlash by the states, and that is a lot of people are pissed off because of what happened here, the way the court ruled, and they're going to create a bunch of restrictions tying the hands of the states in their ability to use eminent domain. So, City of New London, Connecticut, as it says here, had this plan, and they wanted to revitalize the city, and they wanted to create this industrial park. And so here's where it gets kind of sketchy, and that is what they wanted to do is Pfizer, the pharmaceutical company. Pfizer is the one that makes they make a bunch of different drugs, but I think they're like most famous for what's that erectile dysfunction one called? That's gonna drive me crazy. I can't remember the name of it. Let me just Google it. It's Viagra. I think they were the ones that made Viagra. That's what they're most known for. So they said that, look, we want to build a new pharmaceutical plant, I guess, maybe manufacturing plant. I don't know. We're going to build it in New London, assuming there's enough property and there's a cheap property place to build the plant. So New London said, great, we want you to come here. We're going to purchase the land. We're going to compensate these people. But a bunch of people didn't want to sell their land, including Susan Kelo. So they said, well, fine, if you refuse to sell, we're going to condemn your property, and then we're going to compensate you, we'll give you money, and then we're going to use it for public use. And the public use is, and this is where, again, the little sketchy bit, is it a public use to give the land to some sort of economic, revitalization area? The court says it's okay that the use of the Fifth Amendment was legal here. Now, here's the distinction that they're going to make. And you might be thinking, well, wait a minute, that sounds really sketchy because you're just taking land and giving it to somebody who's going to provide more income via taxation, right? The court says, no, that's not what they're doing here. But if that were the case, that would be a problem, right? So the question here is first, is this public use? Right, because that's a requirement of the Fifth Amendment. To say this isn't a quote, I'm sorry. There is no allegation that these properties were blighted, meaning they weren't beat up shacks that, that should have been condemned because they're causing some sort of public nuisance. So you can't claim that, right? Only that these lands prevented development, right? By refusing to sell her home, Kelo's preventing the creation of this economic, park. So the question they say here is, let's look at history. We know that the government cannot transfer property from A to B. So you couldn't simply say, I'm going to take your house, Kelo, I'm going to give it to Pfizer with just compensation. That, they say, would not be public use. But they say they can use authority if it will have future public use. So the question is here, is this actually public use, even if it is conditional on the future? What they say is that this is not a literal requirement that the property be open to general public use. Think about the example I gave you in the last case, the Old Dominion Company with the U.S. military. Now, it doesn't mean that you can only use it to knock down houses and build parks or roads. It means that it has to benefit the public. That's the public purpose, right? It doesn't mean literally public use, because if that were the case, you couldn't use it for things like military bases, right? So they say the requirement is public purpose, not literal use by the public, like a park or a road or something like that. They say that if it will benefit the public at large, then it's okay. Will that do that here? They say yes, because this economic development plan will overall benefit everyone. So what matters is the purpose of the taking, and they cite this Hawaii Housing Authority versus Midkiff case, and they say that was the purpose here is to look not at the mechanics, but rather the goal, right? The ends, not the means. And so they say we have to evaluate the plan in its entirety. He says here clearly this is this is a public use. It's going to benefit everybody, and therefore it falls within the domain of the Fifth Amendment. Finally, the Kelo et al. And some of the other homeowners wanted to have a bright line rule for what economic development would constitute public use or not. They say we're not going to do that. They say that the government pursuing a public purpose often, in some cases, will benefit certain parties versus others. In other words, this will benefit the Pfizer Corporation, obviously, but it's also that doesn't really matter. The question is, does this benefit the public as a whole? Yes, some people are going to win, some people are going to lose. That's the purpose of the takings clause, right? So this still leaves open the question, what about this? What about the worry that transfers from Party A to Party B could occur because Party B could pay more in taxes? In other words, Kelo is paying maybe, some sort of property tax. Pfizer is going to pay a butt ton of property tax. What if the goal of the City of New London is simply to get somebody that's going to pay more in taxes into that property, right? They say that this is a hypothetical question. If you could prove that, maybe you would have a case, but you're not showing that here, right? And we don't entertain hypothetical questions. Basically, they're dodging it. Then finally, what about this claim that there should be reasonable certainty that there's going to be some sort of public benefit? Is that a workable standard? No. They say that would pose an undue burden on the state, and they say that this is not what the purpose of the Fifth Amendment is meant to be. It's simply the state has to show there's a public purpose, that they're compensating these people for the land. It's not a direct transfer from A to B. That's all you need. O'Connor has a dissent, and so does Thomas. So O'Connor's main points are this point number one, and then her sort of third point III bullet here. So she says that the majority manipulates the meanings of the Fifth Amendment's takings clause. As she says here, quote, this effectively deletes the words for public use from the takings clause. She says the purpose of the clause is only for public use. So what does this mean to her, right? She says that the government may only require the forfeit of private property for public use, and while we give deference to state legislatures, we have to determine if the actions are legal, not unconstitutional blanket deference. So what is a legal taking? And this is really one of the cruxes of our argument, and that is I see three categories of taking. These are the permissible ways you can do it. Private property to public ownership. So, for example, what if I knock and say I'm condemning your house, I'm providing you just compensation, I'm going to build a road there. That's obviously public, right? That's the easiest example. What about private? She says private property to private parties for things like public utilities. So I need to build power lines. I'm going to knock down your house, compensate you. We're going to build power lines. It's still benefiting the public, even though the private company is the one that owns, like, let's say, the power lines or something. And then finally, and this is the one that's a little more shaky, and that is certain circumstances, you can take private property and give it to a private party, but there still has to be a public interest served. So this is what she's saying is probably the closest analogy here. So the question is this economic development plan, it obviously isn't going to fall under number one or number two. Does it fall under three? And she says no. Right, this is not a clear public purpose. She says that if there is no legitimate public purpose to the government's taking, then we simply can't uphold it. The petitioners claim that there is no public purpose, there's no harm that's being removed, and so there's no legitimate public purpose in the taking, and therefore, in the past, we've said that, look, there has to be, like removing harm, like condemning a property that's blighted, or maybe you're like a Captain Planet villain and your house just produces pollution, something like that, right? But that's not present here. Finally, Justice Thomas has a dissent. Not surprisingly, it's pretty radical. He says that the majority uses the words public purpose, their interpretation, where essentially anything that benefits the public is okay. He says that it has to be expressly restricted to remove some sort of harm or blight. It can't be any other purpose. This is a bit odd because it also seems like Old Dominion Company, like things like military bases, that doesn't really seem to fit, does it? Right? It seems like this is a very sort of bizarre interpretation of the takings clause, but that's typical Thomas. He says that the government should only take property if it allows for all of the public to use it. Right? He says I would return the original meaning of public use. Again, this is extraordinarily over-restrictive. And then finally, the third point, the poor suffer most from this. It's kind of surprising because he makes sort of maybe an equal protection concern. He says that he makes the claim that economic reasons for giving and taking property are poor. And then this means that poor communities, low-income communities, will be the most hurt. And that by extension, blacks will be more hurt than their white counterparts. And he points to empirical evidence from a case called Berman that showed that blacks were hurt most. The problem, of course, is that this ignores the fact that there is compensation. And in fact, many of the compensation is considerably greater than the value of the property. Right? One of the consequences we get out of this case is there is a huge public backlash after the Kelo decision. A number of states were just dismayed at this decision. And so what they started enacting were constitutional amendments, including, I believe Texas has this requirement too, that not only can the states retain their takings clause powers. That's not in question. But that the only way they can claim a taking is if the legislature or the governor or some combination thereof can do it. So, for example, in Florida, the only way that you can have a taking is if the legislature justifies each taking. So, like basically a legislative act for each taking of public property for public use. So, in other words, they've tied their own hands, right? The other sort of downside about this case is that Pfizer, after receiving such negative backlash, abandoned the property, and then the land that the city of New London spent millions of dollars buying this property, which they assumed was going to be used for an economic development park. The land ended up remaining fallow, not used at all because of the popular backlash. Nobody wanted to essentially use it. So this was a really just huge disappointment for everybody. Right. Okay, when we come back, we'll have our final week. We're going to do more takings clause cases. We've got Nolan, Penn Central, yada, yada. Some of the issues we're going to look at are things like at what point is regulation a taking? So if I put restrictions on the type of property. The other thing is what constitutes an excessive amount of time that equals a taking. So let me give you sort of a hypothetical, silly example. What if you killed somebody, or somebody killed somebody else? Let's assume you're not murderers. Somebody killed somebody in your apartment. The police are going to cordon off the scene, right? It's a crime scene. They're going to say nobody can go in until we've collected all the evidence. Remove the body, yada, yada. At what point does their occupation of that property amount to a taking, right? Because I'm depriving you of all economically viable use. You can't go into your apartment. There's a dead body there. At what point is the occupation and prevention of use of that property a taking? And that's what we'll look at when we come back. Okay, that's it. I'll see everyone for the last week.